Welcome from the heart of Munich to the Data Protection Café. When using AI systems, many companies also face data protection issues. The German supervisory authorities, as well as the European supervisory authorities, have recently taken a position on this, and today we want to take a detailed look at it. The companies, as controllers, decide on the purposes and means of data processing. This also determines the applicability of data protection regulations, and the German supervisory authorities have recently issued guidelines on what to consider when using AI systems, linked below. And now the European supervisory authorities, in the form of a Taskforce of the European Data Protection Board, have also commented on the framework conditions for AI systems. So what applies now for the training of large language models, or LLMs for short? Here are 5 key points from the paper of the European supervisory authorities. Publicly accessible data may generally be used for training the LLMs. A legitimate interest applies here. Safeguards must be implemented to ensure that data, especially from minors as well as sensitive data such as e.g., health data, should not be used later for training the large language models. Secondly, informing the affected individuals. This may be unnecessary in case of large amounts of data. Here, according to the European supervisory authorities, an exception rule from Article 14, paragraph 5 of the GDPR applies. Providers of large language models should create a way to ensure that prompts are not used for training the large language model. Thus, an opt-out option is created here so that the prompts do not flow into the training of the large language models. Fourth, the providers of large language models should inform the affected individuals that the outputs of the LLM may not always be correct, as the system can hallucinate at times, being essentially a language model. And fifth, appropriate processes and technical safeguards should be implemented to address the rights of affected individuals, particularly to fulfill information and deletion requests. Moving on. What should companies consider when implementing AI systems? Here are some points, summarized into 3 key aspects from my perspective. Secondly, an agreement should be made with the AI provider, especially regarding the use of the prompts. Again, the question is whether they will be used for training or not. And secondly, if necessary, also to conclude a data protection agreement with the provider, i.e., a data processing agreement. Secondly, employees should be trained in the use of AI tools. The supervisory authorities also recommend the issuance of a corresponding internal policy. And thirdly, data protection limits must be observed when AI systems are to be used to make automated individual decisions. We have made a separate in-depth video on this topic, which you can find linked below. At its core, it is essential that humans remain in control when it comes to making relevant decisions. To Oscar Wilde, progress is the realization of utopias, and with that to the conclusion, the supervisory authorities clarify the framework conditions in data protection law for training and using AI tools with their recent publications. Employees should be trained in the use of these tools, and particular attention should be paid to data protection regulations with the AI providers. In particular, the training of prompts should be regulated, and a data protection agreement should be made with the AI provider. What else has happened in data protection? The governing mayor of Berlin, Mr. Wegner, wants to reopen the discussion on data protection in Germany. Link to it in the description. Enjoy reading.